Streetman Law. I'm a solo practitioner in Tampa, Florida, and I'm president of the Tampa Lawyers chapter of the Federalist Society. I have the honor today of introducing our next panel, so we welcome you all to come and sit down, and we'll begin. On our next panel, we have the Honorable William H. Pryor, Jr. Judge Pryor is a judge of the U.S. Court of Appeals for the 11th Circuit, where he has served since 2004. Prior to going on to the Court of Appeals, he was the Attorney General for the state of Alabama from the years 1997 and 2004. And when he began his term as the Attorney General, he was the youngest Attorney General in the entire country. He's a graduate magna cum laude of Tulane Law School, where he was editor-in-chief of the Tulane Law Review, a member of Order of the Coif, recipient of the George Dewey Nelson Memorial Award for the graduate with the highest grade point average in the common law curriculum, pretty impressive, and a charter member and president of the Tulane Federalist Society. He's spoken at numerous places. He's received numerous awards and honorary degrees. He's very well respected. He's a Class A debater, and Judge Pryor is also married with 2 children. Next on our panel, we have Justice Charles Canady, who is from the Florida Supreme Court. Prior to going on to the Florida Supreme Court, he served 3 terms in the Florida House of Representatives, and from January 1993 to 2001, he served 4 terms in the United States House of Representatives. Through his service in Congress, Justice Canady was a member of the House Judiciary Committee, and for 3 terms from January 1995 to January 2001, Justice Canady was the chairman of the House Judiciary Subcommittee on the Constitution. He also served as general counsel to Governor Jeb Bush and was appointed to the 2nd District Court of Appeal in November of 2002. In August of 2008, Governor Charlie Crist elevated Justice Canady to the Florida Supreme Court, where he currently serves. And last, I'll introduce our moderator, who is Dean Alex Acosta. He was the 2nd dean ever of FIU Law School, where he began that position in 2009. He's a native of Miami and a first-generation lawyer. He earned his undergraduate degree from Harvard College and his law degree from Harvard Law School, and it's my understanding that he was actually also president of the Harvard Law School Federalist Society while he was there. After graduating from law school, he served as a law clerk to now Justice Samuel Alito when Justice Alito was a judge on the U.S. Court of Appeals for the 3rd Circuit. And he practiced law with the firm of Kirkland and Ellis after that, and also taught law at George Mason School of Law. One more thing about Dean Acosta: he served in 3 presidentially appointed Senate-confirmed positions. He was a member of the National Labor Relations Board, where he participated in or authored more than 125 opinions. And he went on after that to become the first Hispanic to hold the rank of Assistant Attorney General. More recently, Dean Acosta has served as the U.S. Attorney for the Southern District of Florida and was the longest-serving U.S. Attorney for the Southern District since the 1970s. So without further ado, please join me in welcoming our panel.
Thank you, and let me just say this is a real treat for me. While all of you were coming in, I was reminiscing about the first time that I met both Judge Pryor and Justice Canady. In both cases, I was sort of a very young attorney, and hear these great legal minds, and it was wonderful to sort of meet them then and sort of come full circle and have the opportunity to do a soft interview now. So I thought I'd begin, I thought I'd begin by asking some questions about your careers before you joined the bench. Judge Pryor, you made national news back in 2003, as you recall, when you called for the removal of your Chief Justice, I thought that would be an interesting topic to talk about, and I thought maybe the folks here in Florida might be interested in knowing what was behind that.
Well, in 2003, I was the Attorney General of Alabama. I was also a nominee to the 11th Circuit. It was a big year. So while I was being filibustered at the United States Senate, and Senator Canady was saying that I was too conservative to be a federal judge, back home in Alabama, where the Chief Justice had installed a 2-ton monument of the Ten Commandments in the Alabama State Judicial Building. And after a lawsuit against him to remove that monument that he lost in the Federal District Court and in the 11th Circuit, and then the Supreme Court denied cert, and he refused to obey an injunction to remove the monument, I was criticized in Alabama as a liberal sellout. So it was a big year. But I had defended the propriety of displaying the Ten Commandments in courthouses. I had said publicly that I agreed with, before he became Chief Justice, Justice Rehnquist's opinion, where he said that he thought the Ten Commandments had made a substantial contribution to Western legal codes. But when the Chief Justice of Alabama refused to obey an injunction directed against him, entered in a lawsuit where he had been represented by counsel and had an opportunity to be heard, I didn't think that was a particularly difficult call, that he was obliged to obey the injunction. In Alabama, the system of judicial discipline has a body called the Judicial Inquiry Commission that operates effectively as a grand jury, a charging body. And that commission brought charges of judicial misconduct against the Chief Justice, and traditionally the Attorney General's office would prosecute those charges in a special court of judicial discipline in the state that's created by the state constitution called the Alabama Court of the Judiciary. And the chair of the Judicial Inquiry Commission asked me if I would personally prosecute the case. He thought that it being a case against the highest judicial officer, that instead of having, as would traditionally be the case if it were a lower court judge, instead of having an assistant attorney general prosecute the case, he asked if I would do it personally, and I did. Really never had any question about that. I thought it was the right thing to do. Interestingly, the Chief Justice had led an effort to change the rules of the Alabama Court of the Judiciary and successfully changed the rules a couple of years earlier to require a unanimous vote of the Court of the Judiciary to remove a judge from office. And some of the judges on the Court of the Judiciary were elected either trial or appellate judges on other courts in the state court system. But a couple of years earlier, too, the voters of Alabama had ratified a constitutional amendment that put some judges on that court who were laypersons appointed by the governor. So we had lay, non-lawyer judges who served on the Court of the Judiciary. And a lot of the political pundits in Alabama predicted that there was no way to get a unanimous judgment to remove the Chief Justice from office. If someone had told me when I finished law school that I would be able to go home to Alabama and at 34 become the Attorney General of my home state, and a few months before I leave office, prosecute the sitting Chief Justice of the state in the courtroom of the state Supreme Court and deliver closing argument in defense of the rule of law and have it predicted that there was no way to get an order for of a unanimous court to remove him from office, but we did just that. I would have thought that's a great way to end a career as a lawyer.
So, Justice Canady, same question. I recall, I just want to share with the audience that I knew some of your staff when you were in Congress, and the debate back then among us was whether he would live up to a pledge that he made when he was first elected to Congress in 1992 to serve only 4 terms. And at the time I didn't know him personally, or I wouldn't have questioned that, but we were questioning whether he would live up to that pledge, and in fact he did. But before you left Congress, you served as one of the impeachment managers. And I thought the audience might be interested to just hear a little bit about that.
All right. Well, we impeached him, and then we lost in the Senate. Anyway, I can sum that up. It was an interesting experience. I think, though, that it is related to the question about the rule of law, the issue of the rule of law. We felt in the House, as we impeached the president, that it was necessary to do so to vindicate the rule of law and to vindicate the idea that no one in our country is above the rule of law. Everyone is subject to the law. And I think that's an important principle, and I think we actually, in the House, affirmed that principle, and I think that was an important thing to do. The way things turned out in the Senate, I think, was a surprise to no one, but I think that it was still an important action for the House to take, so that we would not just wink at the crimes that had been committed by the chief executive. And the unfortunate thing about that whole process is it took so long that the narrative about it that took hold in the mind of most people in the country was a narrative about personal misconduct, personal bad judgment, marital infidelity, rather than a narrative about perjury and obstruction of justice, which was, both of those are part of the picture. What we were concerned about was the perjury and obstruction of justice. Not that the other things were admirable, but our focus in the impeachment process was on those legal issues. But the public debate was, we kind of lost sight of that, and the ultimate result, I think, was the action of the Senate. So when the subject comes up, I stand by my action as a manager.
Not surprised.
I want to say something about that. You know, not long before you prosecuted that case in the Senate, I took my family to New York for Thanksgiving. We went to the Macy's parade. Our daughters were pretty young back then, and did a lot of fun things. But one night I wanted to get back to the hotel to watch Miracle on 34th Street with my older daughter, who was 7 at the time, about to turn 8. And the reason I wanted to show her the movie was my daughters would sometimes ask me what I did as a lawyer. It was hard to explain to them at that age. And I wanted them to see the scene. I wanted her, particularly the older daughter, who I thought would better understand it, to see the scene where they proved that Kris Kringle is Santa Claus. We had a good friend of our family, a woman who was a magistrate judge, federal magistrate judge in town, and so she knew her, she knew what a judge was, sort of, and she asked me, well, how are they going to prove that Kris Kringle is Santa Claus? And I said, well, every person who knows him is going to come in and take the stand, and they're going to tell the judge what they know about Kris Kringle, and from that he's going to figure out that Kris Kringle is Santa Claus. And my daughter said, now, I'll tell you, this is 1998. I guess that's right. Is that the year?
Yes.
So I've never had a question about oral sex or anything like that. Instead, she says, well, how is the judge going to know if they're telling the truth? And I said, well, each person who comes in and tells the judge what they know will put their hand on the Bible first, and they'll swear to tell the truth, the whole truth, and nothing but the truth, so help them God. And she said to me, didn't the president do that? What I thought was going to be a really great night. And I said, yes. And she said, he didn't tell the truth, did he? And I said, no. And she said, what's going to happen to him? And at the time, I thought, probably not anything. And I want to thank you for having done your duty, Justice Canady, and tell you the one thing I was able to do afterward was to follow with my daughters the stories in the news about the sanctions that were levied against him, the disbarment before the Supreme Court. And I later had the privilege of arguing a case in the Supreme Court of the United States. And when I did, I reminded my daughters that Bill Clinton couldn't do that.
I'm glad you shared that. I wanted to start with a little bit of background on what each of you did before you became a judge or justice. In part because there are many here in the audience that may be considering applying for a judgeship, and there's some that have been recently named a judge. And I was struck by the fact that each of you had very high-profile public elected positions before you went onto the bench. And as a judge and justice, your job is somewhat different, more isolated, I would imagine, more restrained. And I just thought it would be interesting if you talked a little bit, if each of you talked a little bit about how your job changed and how you adjusted to that.
Well, that's a question I have received before, and when I've been asked the question before, the focus has really been on, well, how do you make the transition from being a policymaker, which I was in the legislature and Congress, to being a judge? And isn't that difficult? And I think when I was applying for the first judgeship I applied for, there were some people who were skeptical that someone with my political background could make the transition to being a judge and doing the things that a judge needs to do. Put that behind me. And when I was asked about that, I've told people that it was very easy to make that transition because I always had a very clear conception of the different roles of the different branches. I look back at my application. We got a little heads up about the questions we would be asked. It might not surprise you. But I look back at my application when I applied for the 2nd District Court of Appeal, and I saw that in the question, and I don't know if the application is the same, some of you would know, question 48, give any other information you feel would be helpful to the Commission in evaluating your application. That's where I put in my judicial philosophy. As I looked at that, I was reflecting there at a time when I was working for as the Governor's General Counsel in the executive branch, but I was reflecting there views that I had held when I was a member of Congress and when I was a member of the legislature. And that was that the job of a judge in most instances is to simply apply the decisions that have already been made by others. The decisions that the people have made that are reflected in the Constitution, and the decisions that the legislative branch has made as the representatives of the people embodied in the statutes. And judges are there to read those texts and to apply them. That was what I understood to be the role of a judge when I was in the legislative branch and the executive branch. And when I came into the judicial branch, I simply did my best to be faithful to that vision of judging which I had during all those years. I didn't really think it was very hard to make the transition because I understood how different the role was and how important it was to our constitutional system that judges behave differently than members of the legislature. Because the role under our constitutional system is designed to be so different. So that's basically how I approached it, and I've done my best to be faithful to that vision. My understanding, which I attribute to Alexander Hamilton, and where he summed up, and if any of you have heard me speak anytime, most often I have quoted Alexander Hamilton and the distinction he makes between the exercise of will and judgment. Judges are not there to exercise will.
So I wasn't a lawmaker. My public role, or more political role, if you will, had been as a state executive and particularly as a state attorney general. But I had started my career after law school by clerking for a great judge. I clerked for Judge John Minor Wisdom on the U.S. Court of Appeals for the Fifth Circuit. So I had, from that experience, a conception of what the job was about, and I was surprised upon becoming a circuit judge at really how little things had changed in the way we do our business, and so much of what we do at the 11th Circuit are customs and practices that we inherited from the old Fifth. When I visit sometimes friends of mine on the Fifth Circuit, like Joey Clement, who has Judge Wisdom's old chambers in the Wisdom Courthouse in New Orleans, I'm struck by how down to the colors of the forms that they use for different kinds of motions and cases are the same that we use because of that shared history. So yeah, that was surprising. But I'm like Justice Canady. I understood what the difference was. Now, I don't think it's as big of a leap from having been a state attorney general. If you're a prosecutor, particularly the chief prosecutor, you have a unique role as an advocate in our legal system. The Code of Professional Responsibility says that a prosecutor is a minister of justice, that you have a duty to truth and to do what is right in a way that is not really the same as representing a private client. As Attorney General, I had the responsibility of giving formal legal opinions from the smallest town mayor to the governor of the state, and had performed that kind of objective role in applying law and giving my best legal advice. And often in defending the state or representing the state, I had to do so within the confines of the law. And it's true, I could advocate for changes in the law, changes before the legislature, changes before the courts, but often I was really operating and confined by the law in a way that required me to perform a very objective role. Now I serve also on the U.S. Sentencing Commission, what Justice Scalia affectionately refers to as the Junior Varsity Congress. And it's maybe the most policy-making role I've ever had of all the jobs. We amend the federal sentencing guidelines. We recently reduced the penalties basically across the board for drug trafficking and made it retroactive. Now that's a really cool policy job. It's quite different from the work of case adjudication.
Thank you. So there are a number of clerks in the room, and so I'd just like to turn a little bit to some of the mechanics of judging, and maybe start with how you select clerks. And obviously, you all look for top quality recruits, smart individuals, good writers. But can you offer a little bit more insight into how each of you selects clerks? What do you look for?
Well, I look for people who have good writing ability, people who have demonstrated a level of scholarship, and I do my best to find people that meet those requirements. I'm also looking for someone who will have a good work ethic and will get the work turned around. That's important. Law clerks need to be people who understand who the judge is. I've occasionally had some law clerks who did not understand that and thought that they were there to decide the cases, but no, that's not the way it has to work. So there's that. They have to understand that role also, which is very important. And I listen to my law clerks and appreciate all the input they provide, but ultimately I have to make the decisions myself.
The applicant pool that we get for clerkships at Federal Circuit Court is really astonishing, and it's even been more so as the legal market has been tighter. So, without question, the law clerks are all going to be really high level, budding professionals who have gone. Many of whom have gone to elite law schools, if not, very, very fine law schools where they've been at the top of their class. All of that, of course, is a given. But I look for a couple of other things, too. I want my law clerks to share my perspective about what my job is. I think judging is an objective enterprise, that there are right and wrong answers to the cases that come before us. I don't think of judging as a political enterprise, and I don't want law clerks who think that it is a political enterprise, or that we're there to represent one side or another, or to help the downtrodden any more than we're there to help the rich and the powerful, that we're there to do equal right to the poor and the rich, as the oath that we take says. And so I want, with the busy caseload that the 11th Circuit has, I want law clerks who will challenge me and test me and really dig into the cases that I work on, but at the same time will understand that we're working toward the same end, that judging is an objective enterprise, and that share my philosophy about that. And then the other thing I want is I want people I like to spend time with, because I spend a lot of time with my law clerk, so it's a hard job. It was my first job after law school. It was a formative experience for me. Once you became a wisdom law clerk, you were immediately part of a larger family, of which I remain a part. And I have that same kind of relationship with my law clerks. My law clerks and I have barbecue lunch every Monday. Often they go to my favorite seafood restaurant with me on Fridays. I take law clerks with me, sometimes to a college football game, where I cheer for the Alabama Crimson Tide. The dynasty. I spend a lot of time with them. I have them over to dinner at my house. So I want law clerks who are fun, who I like to spend time with, who are good people, and respectful, have been raised right, have a lot of integrity. And so usually when you've gotten an interview to come in as one of the finalists for the job of a law clerk in my chamber, a lot of time we're really just sizing you up to see, would we like to spend a lot of time with you? Because we're going to spend a lot of time with each other if you're hired.
So an FIU student drove you from the airport, or brought you from the airport, and I asked her, what should I ask you? And she said, just ask him about Alabama football. So I wanted to turn a little bit to opinion writing in the category of mechanics of judging. And I just wanted to spend a little bit of time asking each of you to talk to how you approach opinions, how you go about making decisions. And in particular, one area I was hoping you could talk about is sometimes attorneys or the public have the view that judges write decisions with an eye toward the next decision. That is, that a judge has the view of what the law should be and that writes decisions so that future precedent can build on them and slowly move the law on a case-by-case basis. Do you encounter that in your courts?
Well, I'm always writing for the future, or at least most often in my dissents. So it's,
I fear you may share that with Judge Pryor a little bit.
well, I'm hoping that I will have reinforcements that will agree with some of my dissents one day soon. But no, I think opinion writing is challenging. It's really kind of a scary process because the things we say on the Florida Supreme Court become the law of Florida, and every stray word has the potential for mischief. And so and sometimes the mischief is intended, sometimes it's unintended. So it's a daunting prospect when you consider the impact that decisions can have. So my view is that we, in deciding cases, really should focus on the issues that are before us and try to decide the cases as narrowly as is appropriate, consistent with having a system of rules. I'm not saying it's an ad hoc process, but we shouldn't be reaching out, in my view, to be making points to educate the bench and bar. Now, I'm in the minority on my court in that respect because I think a majority of our court thinks that a part of their function, a major part of their function is to share the wisdom that they have with the bench and bar. I just don't see it that way. I see that our role is to decide the case that is before us, and that we really are going to do what needs to be done, and there's going to be less potential for unintended bad consequences if we focus our process in that way. Now, that's a very important point, a very important matter of discipline in the process that is sometimes lost sight of. So I really think that. And then, and my attitude about it is, there may be things that we could say here that would be helpful, but the case will come along and we can decide the case at the appropriate time. Because there's a great danger in spinning out views about things that have not really presented adequately, and sometimes there are things we just haven't thought about. We may think we have all the wisdom, but we may not, and bad things can happen as a result.
So, there really, if I'm going to talk about the task of opinion writing, I have to really divide that work in two ways. Most of the opinions that I write in any given week or year are unpublished per curiam opinions that in about 80% of our appeals we resolve without oral argument. They're more routine cases where the correct resolution is dictated by a pretty settled precedent, and we just need to tell the parties that we did understand what their case was about. We understood what their arguments were, and here's the answer. That can often be done in 10 or fewer pages, and we want to just get it out as quickly as we can, and be a professional opinion. But we're not really writing the law, so to speak, because what we're contributing there is not adding to the body of precedent. So that's one thing. the 20% of the appeals, though, that we hear in oral argument are far more likely to result in signed published opinions. Those are the ones that my law clerks assist me in preparing and then in drafting. And you know, I agree with Justice Canady. The thing we've got to be careful about is not trying to write too much, trying to write to decide the case that's not before us, not having the stray comment that can be taken out of context in another case. We've got to decide this case, and we've got to decide this case correctly. But we also have to recognize that what we're saying, because it's going to be in a published opinion, is going to be precedent, is going to be the law of the 11th Circuit, and be attentive to that. I want my opinions to be readable, enjoyable to the extent that you can make an opinion enjoyable. Maybe even if you can, in the way you start an opinion, make it somewhat entertaining without making light of the litigants. Sometimes they can be fun, and particularly do it in a way that assists the reader's understanding of what you're trying to do. I view opinion writing as persuasive writing, because I'm trying to persuade the audience that this is the correct resolution in this case. So I usually begin with a strong orientation paragraph that tells you what the main issue in the case is about, how we're going to resolve it, and why, and then try to make everything that follows from that point forward reinforce and support what I've already told you about. And the reader already understands where we're going with the opinion. You know, most lawyers, you know, they have to read our opinions, whether they like it or not. It's not always fun, I know that. So I want to try to make it as easy on you as I can. I want to put the opinions in plain English, and I want to give you an idea where it's going. It's not like a thriller where you find out what the answer is at the end and you figure it all out. I mean, I think you ought to know kind of where we're going when we start out. And some judges have a different philosophy, that you don't really know where it's going to end until you get there. That's not my perspective. So those are some ideas about opinion writing.
Thank you. Well, I'd like to move a little bit to some more general issues now. And I'd like to begin with the issue of judicial independence. And I was telling Judge Pryor a little bit about, I think, the ongoing debate we have here in Florida before our panel around this. I think most of us would vigorously defend judicial independence, but perhaps that means different things to different people. And here in Florida, you see newspapers, legislators, and citizens on occasion, or maybe more often, criticize a judge or a judicial opinion. And that's almost immediately followed by a criticism of the critique, claiming that to criticize is an assault on judicial independence. And you know, you're a judge, and I was curious if you had a strong perspective on that.
I have a strong perspective on this. We are not above criticism, and it is not an attack on our independence to criticize us. I have a lot of respect for Justice O'Connor, but several years ago, she and the President of the American Bar, the President of the American Law Institute, said that judicial independence in America was under unprecedented assault. She wrote an op-ed in the Wall Street Journal that said that. The very next week, I wrote an op-ed saying that I disagreed with that. I think that's a laughable notion, frankly. Let's go back to the Jeffersonian era and talk about judicial independence being challenged. You know, remember when John Adams was appointing the midnight judges, and the Federalist Congress, lame duck Congress, had just created a lot of new judgeships. Thomas Jefferson came in as president, refused to deliver the commission, ordered his Secretary of State James Madison not to deliver the commission of William Marbury that led to Marbury versus Madison. But the other case was Stewart versus Laird. the case involving the new Judiciary Act the Federalist Congress had just passed, and the Jeffersonian Republicans came in and appealed. They abolished the judgeships. They canceled the June and December terms of the Supreme Court. Wow, think about that. They impeached John Pickering, a New Hampshire federal trial judge who deserved to be impeached. He was a drunk. And then they brought articles of impeachment against Samuel Chase, who had engaged in some pretty partisan kind of speeches before grand juries and charging grand juries. He escaped removal from office in the Senate. But think about that. I mean, that's a period of a real challenge to the independence of the judiciary. Or when President Roosevelt threatened to pack the Supreme Court, or when, in the Reconstruction era, when the appellate jurisdiction of the U.S. Supreme Court was removed, and when there was a habeas case before the Supreme Court, ex parte Mercado, that prohibited the Supreme Court then from deciding that case. These are real challenges to judicial independence. But criticism of judges, I mean, that's what our independence is frankly really about. We have strong decisional independence. I don't worry about threats. This isn't like, South America, where I worry about threats from the other branches of government because of the decisions that we render. So the American judiciary is the most independent in the world, and we ought to be very grateful for it. And we ought to be, and the lawyers and judges ought to be jealous guardians of the independence of the judiciary. But we ought to be really fair-minded and balanced when we talk about threats to judicial independence. Chief Justice Roberts a couple of years ago said that the federal judiciary needed a pay raise, and that the level of pay that we were receiving was a threat to judicial independence. Now look, I was happy to take a pay raise, but my independence wasn't threatened by the pay, which I knew what it was when I signed up for the job.
Well, I agree with everything that Judge Pryor said. I think that there's sometimes a very shrill response that comes when particular judicial decisions are criticized. But if you think about it, it's just to say that the criticism of a judicial decision is somehow an attack on judicial independence is nonsensical. Because dissenting opinions, which are an important part of our whole system and are recognized as a very legitimate part of the system, are criticisms of judicial decisions. So there's no logic to this. We have a free country, and people should be able to criticize judicial decisions and judges. Now, sometimes the criticism is unfair. Sometimes judges are criticized for following the law because the people who are throwing out the criticism don't like the law. Well, okay, that's not fair. And I think when those sorts of attacks on judges are made, the bar should respond and point out that the judge is following the law. But the notion that criticism in the public of decisions is going to undermine the independence of the judiciary, I really think itself is an attack on the integrity of judges. Because to assume that judges will behave differently because they're criticized is to doubt their integrity, is to challenge their integrity. Ultimately, judicial independence does depend on the integrity of judges, on their faithfulness to the oath they've taken to decide cases independent of anything but the law. And so I think that this whole, the people that get up on their high horse and say judicial independence is being attacked anytime there's a criticism of judges really are wrong in multiple ways.
Thank you. So I did a little bit of research to prepare for this. I went on the highly reliable Wikipedia, and I looked up a little bit of information about the Federalist Society, and I was surprised to see that we're now approaching the 35th anniversary of the Federalist Society, and that its membership now has more than 60,000 practicing attorneys in more than 80 chapters around the nation. You know, that's much larger than it was when I was a student in law school, when I think there might have been, I don't know, 24, you know, maybe 36 chapters. And so it struck me, is there impact? Are all these gatherings having impact? And so I wanted to ask, over the course of your careers in law, have you noticed a change in the way that judges approach judging? Is there a greater reliance on the plain language? Is there a greater reliance on originalism now than there was 20, 25 years ago?
Well, I don't think there's any doubt that there's a greater respect for the text of written laws than there was when I was in law school and when I first started practicing. And if you want a good example of it, look at the decisions of the Supreme Court and their citations to legislative history in the late 70s and early to mid 1980s and compare it with today. The Supreme Court is far less likely to rely on legislative history, and there's an infamous quote from a Supreme Court opinion back in the 70s where one of the justices wrote, it was actually Justice Marshall, wrote, you know, we can't find an answer in the legislative history, so we're going to resort to the text. Kind of an embarrassing moment for the Supreme Court. You know, Justice Scalia has changed the world. I've heard Justice Kagan speaking at Harvard Law School not long ago, where she talked about just this and considers herself a textualist. In many ways, I think can be credibly described as a good textualist. That Yates case that the last panel talked about, without regard to whether you think that was a good prosecution, a bad prosecution, I think, I wasn't on the panel of the 11th Circuit that decided that case, but there was a Florida judge, Judge Jordan, who was on that panel. I think the dissent in the Supreme Court was right about the text, and it was written by Justice Kagan, joined by Justice Scalia, in which case in that dissent, she referred to Justice Scalia's new book about the canons of interpretation a couple of times. It's really she's also a really first-class writer. If you want to read some really interesting opinions where they're dueling in their interpretations of a text, read the Yates opinion. The majority opinion, the plurality by Justice Alito, the dissent, they're all very good opinions, but look at how seriously they take the text of the Sarbanes-Oxley Act that they were debating. And that's true in a way today that it was not nearly as true 30 and 40 years ago.
Well, I agree with that, and I think that Justice Scalia does get a lot of the credit for that. I also think the Federalist Society gets some credit for that, because I think that the work of the Federalist Society has helped push that whole movement forward at different levels. And so it's been a remarkable change. Now, sometimes people that call themselves textualists will take liberties, but it is remarkable that people who once would have felt no obligation to do more than maybe kind of take a glance at the text, now understand that they really need to justify their decisions in terms of the text, and I think that is definitely progress.
We've got a little bit of time, not a lot, but we have a little bit of time for some questions from the audience, if anyone would like to step up to the microphone.
Usually, you know, I'm asking you the questions, so this is your chance.
Judge Shepard.
I was hoping you wouldn't mention my name. I
We
can't.
know who you are.
The first recipient of the Good Shepherd Award.
Should I sit down now? It's not often that you get to ask a question from my position to a superior. I thought your comments on legislative history were very interesting. I'm interested in a little more elaboration from each of you on that point as to what purpose is there in legislative history, and both federal and state. You can each talk about the other as far as I'm concerned. But I'm also interested in your views on administrative deference. Should judges defer to interpretations of statutes or regulations by administrative agencies?
I'll be happy to start. In terms of legislative history, I don't find legislative history really all that useful in interpreting statutes. I think there are a lot of reasons to be against the use of legislative history. I agree with Justice Glue's perspective about it. No, but there's this great exchange on the floor of, I guess it was the U.S. Senate, between a couple of senators a couple of decades ago, where they talk about legislative history, and no one votes on it. No one can move to amend it. No one reads it. Is one of the, at least in the legislative body, it's written by the staff. It's not the law. The text is voted upon is the law. The very limited use, I think, for legislative history is if you have a question of linguistic usage, if you have a term that you're trying to determine what the meaning of the term is it an ordinary meaning of that term, or is there some technical meaning of the term? The legislative history can shed light on that in the same way that a dictionary could shed light on that. And I think you can use the dictionary too. And it's okay to use the legislative history as long as you understand it's no more authoritative probably than the dictionary is. And then the other is if you're concerned about someone's making an argument that the text, if he were to interpret it in a certain way, that would be absurd, and they invoke the absurdity canon. And you go to the legislative history and you find that they actually talked about that very interpretation that's being argued is absurd. Well, you can use legislative history in that context to rebut the absurdity canon. But aside from those two very limited usages, I wouldn't use legislative history. Administrative agency deference, I don't have a problem with the Chevron deference framework. When an administrative agency is charged with the enforcement and administration of a law, and the law has more than one plausible meaning, and they choose a plausible interpretation, and that's their long-standing interpretation and enforcing the law, I don't have a problem with deferring to that for a lot of, I think, very sound reasons. So long as we remember, though, that there really has to be a genuine ambiguity, and there really has to be a plausible interpretation. If the law is clear, then there's nothing to defer to. But in the instance where where Chevron really operates, I think that deference is appropriate.
I'll say a word about legislative history. I made some legislative history myself. I was in Congress. Of course, in the legislature, I guess I would have made some legislative history standing up on the floor and comments and in committee. It's not as extensive in the state legislature as in Congress, and I have my name on some committee reports that came out of the Constitution Subcommittee. So but I know how all that works. Now, I think if my name was on a committee report, we were trying to be faithful. We were saying things that were consistent with the text. That would have been our object. But I also have seen how that works in other contexts where people couldn't get something in the bill. They'll therefore try to get something in the legislative history. Well, that's not the way that's supposed to work. I mean, you're supposed to, the House and Senate are supposed to vote on text. That's what becomes a law. So I think the most apt description I have heard of the use of legislative history is it's like looking for a friendly face in the crowd. And that is looking for something in this massive material, and frequently there is a massive material that will support, in debate or otherwise, that will support a particular result in a particular case. And I don't think that's the way cases should be decided, and I don't think that's being faithful to the text, which was passed by the House and Senate and became law.
I think we have time for one more question.
I guess that's me. Susan April, I think I'm almost a 20-year member of the Miami or South Florida chapter. This is a question directed, I guess, particularly to Judge Pryor. In the federal rules, or in practice, when one is, when a litigant loses on a motion to dismiss, say for lack of jurisdiction, personal jurisdiction, or any jurisdiction, the rules provide that you can take or you can seek discretion of the court to file an interlocutory appeal. And so I'm wondering if there are factors that you look at. I've never had one of those taken. I mean,
It wouldn't be interlocutory. I mean, if your case is dismissed, it's a final order.
Oh, no,
You'd be
I'm
able-
sorry. I said, I misspoke. Denial of a motion to dismiss.
Oh.
So you're looking at a case that could go on for a long time versus be over. And so I've been involved in seeing others that are, rejected. And I wonder.
You're talking about a 1292B appeal?
Yes.
Mhm.
Thank you very much. More succinctly.
Mhm.
So I'm just wondering if there's any factors, and I'm not sure this is a fair question, that you in particular think should be considered, because to me it seems like in some cases perhaps the fact pattern is much more obvious than others, that this case ought not to go on for years and then in the end.
I can't really direct you to anything other than what you would find in Wright and Miller. It has to be a controlling question of law. There has to be a reasonable division of opinion about it. It has to be really a pure question of law. Very often when we get those applications for that, to certify a question like that, we find that they're really way too fact-bound and not appropriate for that kind of appeal. But I don't really look for anything other than what our case law standards say we're supposed to be looking for, and it's a difficult standard to meet. I can't think of too many 1292Bs that I've certified in 12 years on our court.
We're a little bit behind schedule, so I think we should probably move to close, and I want to do so with a fairly open-ended question. One of my former bosses would caution us against using the word pride. He didn't like the word pride. So I'm not going to ask what you're most proud of, but I wanted to know if there's something, a specific opinion or something specific, a specific item that brings you great satisfaction as you look back and you say, that's something that I take satisfaction from.
Well, in terms of opinions, I enjoyed writing a brief opinion in a case called Harris versus State. a dissenting opinion. That case.
They're always more fun, aren't they?
Yeah, but it was a very brief dissenting opinion, and that was a case about whether the alert of a drug detection dog during a traffic stop provided probable cause for a search of the vehicle. And there's a lot of history in the courts of Florida about this issue. Well, our court decided that the stop in that particular, the search in that case was not justified by probable cause, and basically set up a pretty elaborate framework for establishing the qualifications of the dog in question. I thought that was inconsistent with the law of probable cause and the kind of the common sense approach to making judgments about probable cause as part of the federal constitutional law. And the U.S. Supreme Court agreed with my position unanimously. So I enjoyed that. I would like to say I enjoyed that. In relation to a comment about a particular justice, I will say that I loved reading Justice Kagan's opinion for the majority in that case.
I guess the thing I take, I don't know if pride's the right word, but the thing that pleases me most is to see the success of my law clerks. I administered the oath to one of my law clerks, who's the first of my former law clerks to become a judge. He's now a judge on the Georgia Court of Appeals a few weeks ago. And he was, before that, had been the Solicitor General of Georgia, the first Solicitor General of Georgia. I've had the former clerk who's the Solicitor General now of Alabama, one who's the Solicitor General of West Virginia, the Deputy Solicitor General of Tennessee is a former law clerk. I've had several clerk on the Supreme Court of the United States, two who are there right now clerking for Justices Thomas and Scalia. I've got another one who's going to clerk up there next year. I had two clerk up there last year. I've got a number who are now assistant U.S. attorneys. I've got them, who are on both sides of the plaintiff's bar, defense bar, but when I see them succeed and the close relationship that I enjoy with them and the references that I am able to provide for them and the advice that I give them as they make career decisions, they always call me. Nothing really makes me happier than that. If I've in any small way contributed to their public service and success, then that gives me really great satisfaction. I love seeing that.
Judge Pryor, Justice Canady, on behalf of the Federalist Society, thank you for joining us tonight. Thank you.
Thank you all, and thank you very much, Judge and Justice, for the discussion. Thank you all for joining us. We now have the fun part of the evening, which is the reception. The reception is actually going to be right next door, so if you wander out there, you can do that. On your agenda, you'll see that there's some Dutch treat dinners. I know there's some folks that have organized some dinners. Hopefully you'll find some folks that are collegial that you can have dinner with tonight. And I'll just remind you that we start tomorrow morning. Breakfast starts at 8 a.m. And then we have a day of panels that I think will be exciting. Thank you very much for coming.